to Rico.
Gabe Holbert, you can unmute and speak.
Members of the Contractors State Licensing Board, my name is Gabe Holbert and I represent Home Run Financing, a property assessed clean energy company that provides affordable financing for energy efficiency, water conservation, and disaster resiliency improvements to property owners voluntarily through their property taxes in California, Florida, and Missouri. PACE started in California over a decade ago and has provided equitable access to financing for residents throughout the state, while also providing opportunities for the contractors who step up to complete these property improvement projects. This transformational public policy makes the green economy more accessible to property owners throughout California, while also giving local governments a tool to lessen environmental impacts in their jurisdictions. Since AB 1284 was passed in 2018, the PACE industry has implemented rigorous consumer protections, including strict underwriting standards, recorded calls where assessment terms are discussed, and verification of one's ability to pay, among other measures. In addition to these consumer protections, AB 1284 established the California Department of Financial Protection and Innovation, the DFPI, as the state's regulator of the PACE industry. PACE providers also do not pay contractors until verifying projects are complete, use a maximum pricing list to ensure projects do not exceed reasonable prices, and have additional measures in place to protect consumers from bad practices. Since becoming licensed by the DFPI, the PACE industry's open complaint rate through their formalized complaint process has remained low. For example, of open complaints against the PACE industry, only 0.1% of all complaints were unresolved as reported in the latest DFPI annual report. This statistic is a testament to not only the PACE industry's strong commitment to provide high quality consumer protections, but furthermore, a sign that the regulations are working. This data also does not support the $32 million figure of taxpayer money being proposed as necessary for a restitution fund, and further supports the need for a thorough review of the proposed funds amounts and more clear guidelines for claims. The basis for this restitution funds appears to be an analysis of outstanding legacy customers left uncompensated by the bankruptcy of a PACE provider who hasn't offered PACE since 2019, who also never participated in the DFPI complaint process. Customers of a company who is no longer in business, not because of any behaviors of the highly regulated and licensed PACE companies currently doing business in California who play by the rules of the DFPI and the over 325 jurisdictions they're operating in. Ensuring bad contractors do not participate in PACE is vital to the success of both the PACE industry and contractors throughout California who conduct their business in a fair, honest manner. However, this restitution fund proposal doesn't address either. Instead, it opens up the rest of the industry who has worked hard to be in compliance with laws and industry standards to criticisms that doesn't reflect the very honest and regulated manner in which we conduct our business. This proposal for a restitution fund ignores the law, regulation, and internal policy that has been successful at reining in bad practices and ensuring a high level of consumer protection for property owners throughout California looking to make their homes more energy efficient, safe, and resilient to the challenges brought by climate change. Furthermore, this proposal unfairly punishes the entire PACE industry for the behaviors of an actor who is no longer in business. We suggest that additional research and an independent, thorough review be done before the board can effectively approve the fund as proposed at this time. Thank you for your consideration.
Thank you. Okay, register folks.
Yeah, just a kind of a quick update. Chair Teichert has had to depart the meeting, so Vice Chair Diana Love has taken over the chair duties. And Committee Chair Galarza, just to let you know, I think there's 4 or 5 hands that are raised. My thought would be that our moderator would advise the speakers to the 3-minute limit that you put in place. When they get within 30 seconds of the 3-minute limit, he'll be letting them know.
Thank you so much. Rico.
All right, Allison Snow, you can unmute and speak.
Hi, my name is Allison Snow. I am the director of the University of San Diego's Housing Rights Clinic, and I also spent 13 years leading the Consumer Protection Program at the Legal Aid Society of San Diego. I have had the opportunity to witness the devastation created by the PACE program, and not one of these PACE administrators is innocent. We have filed lawsuits against each and every one of them, and it is a widespread, well-known issue. Why are we seeking money from the state budget? This is a unique lending program. It's basically a government-created problem. The government actually went in and changed the laws in order to be able to provide this type of financing. And it really circumvented the consumer protections that were put into place in the wake of the subprime mortgage crisis through the Dodd-Frank Act. Number one of which should be the biggest red flag, is there was no ability to repay these loans requirement. Now, let me tell you what that looks like. I had a gentleman, my first client, who came in, his property taxes went from $300 a year to $17,000 a year under this PACE program. A gentleman with no internet access, no email, and at least home run financing, which used to be known as PACE funding financing, was one of the actors in that program. And so we have seen this time and time again, where these different PACE entities come in and have a long list of clients who have received no remedy. I have 3 clients right now with PACE funding where it wasn't even the record owners of the property who entered into the contracts. So can you imagine the record owner's surprise when there are hundreds of thousands of dollars, literally over $300,000 of liens by non-record owners of the properties? These cases are still in active litigation, and these occurred starting as far back as 2017. We're still in litigation. Without relief, there's no remedy. Each of these property owners were forced to sell their properties in order to cover the ridiculously high tax assessments due to the PACE fraud. Here in San Diego, I represent a number of clients who are part of the Martinez construction cases. Earlier, you discussed the eco-solar cases. The Martinez
Allison,
cases,
you have 30 seconds.
Are $2.1 million in fraud, so double the amount that we saw with eco-solar. And these Martinez construction cases still have not been resolved. A number of these are Y Green, Renovate America, and other PACE lenders. And these people have not received the relief that they're entitled to. They were bundled and packaged and sent to investors. And so now the government entities are saying they can't take care of it. And so we really need this fund. Without any remedy, there is no justice. And this PACE fund affords these people the opportunity and access to a remedy. So I encourage the CSLB to endorse this request for the budget. Thank you so much.
Thank you.
All right, Natasha Blazer can unmute and speak.
Can you hear me?
Yes.
Yes.
Great. My name is Natasha Blazer. I'm an attorney at Housing and Economic Rights Advocates, or HERA, and we are a statewide legal services organization. And one of our areas of focus is home ownership preservation, which has led us to work on a lot of these PACE cases where the assessments are threatening the homeowner's ability to retain the home. We have worked with homeowners affected by PACE in over 20 counties across the state. I can confirm that we do have PACE clients right now with ongoing and unresolved disputes with PACE administrators, including those who have spoken on this call, where homeowners have brought their complaints and harms to the administrators and no relief has been provided to date. The vast majority of homeowners that HERA has assisted with any form of home improvement issue in the past 5 years have involved the PACE program, which is why a PACE-specific fund is so vital. I also want to note that the homeowners that we have worked with on these issues are overwhelmingly low income, overwhelmingly elders, and our clients impacted by PACE are also disproportionately from communities of color and Spanish-speaking communities. And so these are the homes that need to be protected. HERA continues to get new clients and new cases that involve consumer fraud in the PACE program today. It's an ongoing issue. And this is partially due to the ongoing originations, but it's also because so many consumers who were defrauded years ago are only now being able to seek and obtain assistance. So many of these homeowners were solicited before any of the additional consumer protections were enacted, which means that they have not benefited from any legislation regarding these issues to date. And this is in addition to the substantial barriers that consumers face both in discovering the fraud in these transactions, these complex transactions, and then obtaining assistance, let alone relief for that fraud, as other people have discussed today. So the fact of the matter is that a restitution fund of this kind would make a significant impact in the lives of many California homeowners across the state, particularly those from marginalized communities who have experienced these wrongs and have not been made whole. It would provide much needed relief to homeowners who have no existing alternative avenues of recovery available to them. And so I would ask the board to support these efforts to make these public funds available to these harmed homeowners. Thank you.
Thank you.
All right, Daniel Alper, you can unmute and speak.
Good morning, members of the Contractors State License Board. My name is Daniel Alper. I'm a staff attorney with Housing and Economic Rights Advocates, and I urge the board to endorse the budget request for the creation of a PACE restitution fund. By using home improvement contractors as its sale force, the PACE program subjected some of California's most vulnerable homeowners to high-pressure sales tactics, fraud, and illegality. As a staff attorney at HERA, I've advised and assisted over 25 individual homeowners, the majority of which are senior citizens with PACE financing issues. At least 10 of those homeowners took out HERO financing, and any chance for meaningful relief was lost when HERO program administrator Renovate America filed Chapter 11 bankruptcy. In at least 5 of the cases I've worked on, the contractor salesperson misrepresented the price and made up a fake email address to which the PACE financing documents were sent. And those homeowners did not receive their PACE financing documents for months, in some cases more than a year after the transaction was complete. So the delayed discovery of fraud in many of these cases prevents homeowners from being able to take legal action within the statute of limitations, and the courtroom doors are closed to those victims. In addition, many homeowners report that contractors marketing PACE financing would not take no for an answer, making repeat visits to the home and continuously pressuring the homeowner. In one such case, a disabled elderly homeowner was repeatedly solicited for PACE finance improvements that she did not want or need. And after agreeing to the transaction, just for the sake of getting the contractor to stop bothering her, her property taxes increased 10 times for substandard work that significantly damaged her property. As a disabled senior citizen on a fixed income, she did not have the will or the resources to bring a lawsuit. In another case, a 70-year-old disabled woman living on less than $1,000 per month in Social Security agreed to PACE financing for solar panels that the contractor salesperson told her would cause her electricity bills to go down to $30 a month. Well, now she pays over $300 per month for electricity and has had to rely on property tax postponement to afford her home expenses. The government entity, Western Riverside Council of Governments, responded to this homeowner's claim, stating that she should have brought her claims within 6 months to be considered. And Western Riverside Council of Governments has responded similarly to all 7 requests for relief that I've made on behalf of homeowners, apparently without considering the merit of those claims or the unbearable financial burden suffered by the victims.
Daniel, you have 30 seconds remaining.
Thank you. There was no ability to repay requirement at the time this homeowner took out PACE financing. If there had been, it is highly unlikely that she would have been approved with her limited monthly income. A state-created restitution fund is necessary to provide relief for these vulnerable homeowners who would otherwise be left without a remedy. And the CSLB's efficient administration of the Solar Restitution Fund demonstrates that a PACE relief fund proposal can be successfully implemented under CSLB's oversight. Thank you.
Thank you.
All right, Joe Jaramillo, hope I'm saying that correct. You can unmute and speak.
Jaramillo. I'm a senior attorney at Housing and Economic Rights Advocates based in Oakland. And I thank you, Contractor State License Board members and registrar, for considering this important proposal to consider endorsing it. I urge you to support it and endorse it. It's a much needed measure for all the reasons stated by the prior speakers. I've been working on assisting homeowners with the many problems and foreclosure risk caused by PACE assessments and liens since 2017. And we have contracts going back to 2015, and our clients have those contracts when PACE first started operating in California. And as mentioned before, there's a statute of limitations issue for people with those older legacy cases. They may not be able to get relief. Even when litigation is filed, that litigation can take years. And I want to highlight a very specific problem, and that is the foreclosure risk that these people face. And it's not just the foreclosure risk from the PACE program itself, which does have the right to bring a judicial foreclosure action to collect, but it's because these folks often pay their property taxes through an escrow account on their mortgage. And when the property taxes go up due to a PACE assessment, and as we've heard, they can double, triple, quadruple, they could even make their property taxes go up 10 times depending on the amount of the PACE assessment. Then that eventually will increase their mortgage payment because the mortgage servicer is paying through an escrow account to pay the property taxes every year. And the mortgage servicer can even add a cushion on that. So it's not just the amount divided by 12 for the property taxes, but there's an extra month or two of cushion that could be added to that. So we've had homeowners whose mortgage payments have gone up significantly, have doubled, and have put them to an unaffordable amount. And I'll give you an example of a case that we handled for a senior citizen couple in Oakland who unfortunately, due to the PACE assessment, lost their home precisely because of the way that it affected their mortgage payment. This was a couple who wanted to do home improvements for their roof because of the rains coming up, and they were told that by an authorized PACE solicitor agent, a contractor who wanted them to finance through PACE, that they would not have to pay back the PACE assessment.
Joe, you have 30 seconds remaining.
Until they either until they passed away or when they sold the property, which was false. It immediately raised their property taxes, which raised their mortgage, which became unaffordable, and unfortunately they lost their home. While we were able to get them some relief at the afterward, the PACE restitution fund could really help people who are in danger of losing their homes because of this, and we urge you to support it.
Thank you.
There are no more hands raised for public comment.
Thank you, Rico. So it's important to note that there is no proposed language was available when the Legislative Committee met on this item in February 16th. Hence, the committee is recommending that the full board approve supporting in concept the proposal to create a PACE resolution fund for consumers harmed by PACE loans. Since this recommendation comes from the committee to the board, it comes to you as a fully formed motion and does not need a first or second prior to vote. Since a bill of this language is not yet in print, this recommendation is made with the understanding that staff will continue to work with the proposed sponsors, DCA Legal, PACE administrators, the solar industry leaders, and any opposition on proposed legislation. The Legislative Committee Chair will keep informed of meetings and possible needs for a Legislative Committee meeting to review and discuss any introduced legislation. With that, I welcome board comments.
Chair, David Del Torre.
Yes, David.
Yeah, I want to thank all the speakers that came out or who joined in and spoke on this item. I would have like to have heard from some of the homeowners that were impacted negatively. I think it would have been a lot more powerful testimony, but I would like to hear, from some of the homeowners. I know attorneys came out and spoke on some of their behalf. I just think it would be more impactful. That's it. Thank you.
Thank you, David. Any other members of the board?
Michael Mark has his hand raised.
Please, Mr. Mark.
All right, thank you, Chair. So, to my understanding, it sounds like the proposed language wasn't before the legislative committee. And then there is like the staff recap and staff analysis of the items. There was a mention by one of the commenters of kind of a statute of limitations. What was that why on page, I think 148 of the packet or 146 of the packet, it's saying anything before January 1st, 2016, that this language would not become in effect. So I from my understanding, some of those bankrupt PACE administrators who did some faulty ones at the beginning, this won't help those consumers. Maybe that's a question for registrar.
Some of this language is modeled off after the legislation that created the Solar Recovery Fund at CSLB. And the statute of limitations expires after January 1st, 2016. So we can only consider contracts or work performed after January 1st, 2016. I believe that's where it came from.
And I guess a follow-up question. So the goal of today is to make sure and hopefully present this language and get it inserted into the budget for the governor's office, correct? And then to create this program as a state of California program for consumer protection?
Yeah, what's being asked is if the board would support in concept the creation of a PACE recovery fund. And the board is not sponsoring the legislation. You heard from Stacy Tutt and her associates that have spoken to legislators. They would be the ones, it's my understanding, they'll be the ones to approach the legislature, get legislative language introduced, and then that would come back before the board. But they're asking if the board would support in concept this creation of this PACE recovery fund. The language that you see in the packet, we had a meeting yesterday because I know there's some concerns about that language. And what we asked yesterday is if the board's counsel, John Ken, can be part of the discussion on how that language could be improved upon. Everyone seemed to be in agreement with that. So it's kind of a work in progress, just asking the board, I guess the legislative committee is submitting this to the full board for consideration on whether the board would consider, in concept, would support this recreation of this PACE recovery fund.
Oh, okay. Thank you, Dave. Appreciate that.
Any other comments from board members? Rico, I believe there are members of the public that are available to speak.
Yes, we have one hand raised. I believe it's Carlton Overstreet calling in. You can unmute and speak.
Hi, good morning, board members. This is Carlton Overstreet. I am the heir to Carlton Overstreet Sr. He was not a authorized homeowner who was solicited by PACE to start the program. In his absence due to his death in 2017, I just want to testify that PACE has operated under a fraudulent operation for years. I'm not sure why they're even still in business. That's neither here nor there. I am represented by Allison Snow, our attorney on record, and appreciative of her efforts. Both my sister and my uncle, who were living in the home due to property tax increases, had to relocate and sell the home. That caused our family a huge inconvenience, obviously. I just want to go on record that the representative from PACE that came to solicit our family's business did not do their diligence in finding out that the estate was represented by 3 family members. They only went after my father, who was 1/3 of the family's estate. His 2 other brothers were kept out of the business operation. As a marketing ploy, they utilized alcoholic beverages, purchased 6-packs, 12-packs, 24-packs to get my father to sign up for the program and to also work as a recruit, knowing that alcohol was his Achilles heel. That's just a fraction of the story. We've been waiting patiently on litigation since 2017 and have been tight-lipped publicly as far as outing PACE in the media. So I stand by any organizational and efforts, whether it's state-related, government-related, legally related, to rectify this fraudulent behavior that PACE funding and all entities representing PACE's bankruptcy claims have been short of rectifying with homeowners such as my family's estate. Thank you.
Thank you. Any more public comment, Rico?
Yes, Veronica Soto Miller, you can unmute and speak. Veronica, I'm sending you a request to unmute, and then you can speak. One more try. Veronica, are you able to unmute? Nope. Veronica's hand went down, so no other public comment.
All right. Well, with that, members, Mariah, would you please call roll?
Mary Teichert, approved absence. Rodney Cobos.
Aye.
David De La Torre.
Aye.
Miguel Galarza.
Aye.
Susan Granzella.
I vote aye, but should we not restate the motion?
I could do that, yes.
If you could do that, I think that would be helpful right now.
No worries. I appreciate that, Susan. I will reiterate what the ask is from the committee of the board. The committee of the board makes a recommendation to the full board as a fully formed motion that since there is no bill to be considered at our February 16th meeting, the recommendation is made that there's an understanding of the staff will continue to work with the proposed sponsors, who are DCA Legal, PACE administrators, the solar industry leaders, and any opposition on proposed legislation. So that is the motion, is for staff to continue to work with all the stakeholders to come up with a resolution that would ultimately become a bill that we can support.
This is John Ken. I believe you might be misstating the bill, Miguel. The motion was on committee's recommendation that the board approve supporting in concept the creation or proposal to create a PACE restitution fund for customers.
That is correct. My apologies, John. Thank you for that, restating that.
Thank you.
Are you comfortable with that, Susan?
Yes, aye.
Any members who previously voted? If not, continue the vote, Mariah.
Alan Guy,
Aye.
Jacob Lopez, approved absence. Diana Love,
Aye.
Michael Mark,
Aye. Aye.
Stephen Pinelli, approved absence. James Ruane,
Aye.
Johnny Simpson,
Aye.
motion passes.
Thank you, Mariah. With that, I would like to digress back to item 4, which is a review and discussion and possible action on legislative proposal to apply a 3-year statute of limitations to violations for allowing fraudulent use of a contractor's license. That can be found on page 137 of your booklet. This proposal would increase the statute of limitations for misdemeanor violations pertaining to the unlawful use of a license. The proposal is supported by complainants receiving from consumers in designated disaster areas where licensed contractors unlawfully allowed unlicensed contractors to use their license for disaster rebuilds. Fauna, would you please provide the details on this proposal? Fauna.
Sorry, my unmute button didn't work. I want to start by addressing feedback issues that were going on earlier. We are aware of them, and we have technical folks working on solving it. So if it hasn't been solved yet, hopefully it will, but I am going to proceed with the agenda, and apologies if it's hard to hear. So this proposal, it's another board proposal. It's not a bill. It's we would like to make it a bill. So this would increase CSLB's impact on consumer protection in disaster areas by addressing criminal misuse of a license. CSLB conducts outreach at local assistance centers operated by Cal OES to educate homeowners about contractor licensing requirements. However, a consumer cannot protect themselves by checking a license if the unlicensed contractor is unlawfully using the valid license of another contractor. Specified violations of the contractor state license law are classified as misdemeanors, this being one of them. However, the contractor state license law does not classify this as a misdemeanor. Instead, CSLB derives its misdemeanor authority from the Business and Professions Code, Section 119. This section applies to all boards and bureaus within the Department of Consumer Affairs. Section 119 addresses fraudulent use of a license, including using a fictitious license, lending a license to another person, or allowing other unlawful use of a license. The statute of limitations for misdemeanors are set by Penal Code Section 802. The current statute of limitations for Business and Professions Code Section 119 is 1 year from the date of violation. Because consumers often do not complain within that 1 year, once we receive that complaint, we often don't have enough time to seek criminal charges for these violations, and our only avenue is administrative disciplinary action. This proposal would add Business and Professions Code Section 119 to the Penal Code Section 802 that specifies the statute of limitations would be 3 years from the date of discovery of the violation. This proposal would provide CSLB time to investigate and refer misdemeanor violations of fraudulent license use for prosecution. Fewer cases would be disqualified from criminal prosecution due to the statute of limitations. Also, we have to investigate each complaint we receive. Therefore, this proposal would promote a more effective use of CSLB investigative resources without creating a fiscal impact. We are requesting your approval to also share this draft language with the Office of Senator McGuire. Thank you.
Thank you, Fauna. Are there any board members who would like to make a comment or have questions on this item?
Or no hands raised.
Thank you. Hearing and seeing none. This proposal was reviewed by the Legislative Committee at our meeting on February 16th. The committee recommends that the full board approve sharing this proposal to increase the statutes of limitations for misdemeanor violations of the unlawful use of license with the Office of the Honorable Senator McGuire. Since a bill with this language is not yet in print, this recommendation is made with the understanding that staff will further confer with the chair of the legislative committee to seek authorization to take a position on any subsequent bill. Since this recommendation comes from the committee of the board, it comes to you as a fully formed motion and does not need a first or second vote. I would take comments again from any board member. Hearing and seeing none. Rico, are there any public comment on this item?
No public comment.
Thank you. Mariah, would you please call roll?
Mary Teichert approved absence. Rodney Cobos.
Aye.
David De La Torre.
Aye.
Miguel Galarza.
Aye.
Susan Granzella.
Aye.
Alan Guy.
Aye.
Jacob Lopez approved absence. Diana Love.
Aye.
Michael Mark.
Aye.
Stephen Pinelli approved absence. James Ruane.
Aye.
Johnny Simpson.
Aye.
Motion passes.
Thank you, Mariah. I would now direct you to the next agenda item, which would be item 6, which is an update, review, and discussion of possible action items on 2022-24 legislative strategic plan objectives. If you would turn your booklets to page 157, the board's 2022 through 2024 strategic plan identified legislative goals and objectives. Fauna will provide an update on objectives 3.2 to review policies, procedures, and current practices for compliance with the Administrative Procedure Act to ensure appropriate decision-making. Fauna?
Thank you. The legislative division had 2 vacancies for some time. Now that I'm in place, and we have also hired a regulations and legislation specialist, Diana Godinez, we would like to request an extension for this objective. This year, we will be writing the board sunset report. That process requires us to review our law, our regulations, policies, and procedures. So we're asking that the due date for this objective be aligned with the sunset report, which will be submitted to the board for approval at the December board meeting.
Thank you, Fauna. Are there any board members that have any questions or comments on this item? Hearing and seeing none. Staff recommends, the extension and due date of this objective to the December 2023 board meeting. Is there a motion and a second to extend the due date for this objective until December of 2023?
Johnny Simpson, I would make that motion.
Michael Mark, second.
Thank you, Mr. Mark. Any comments from the board? Rico, are there any public comments on this item?
No public comments.
Thank you. Mariah, would you please call roll?
Mary Teichert approved absence. Rodney Cobos.
Aye.
David De La Torre.
Aye.
Miguel Galarza.
Aye.
Susan Granzella.
Aye.
Alan Guy.
Aye.
Jacob Lopez approves absence. Diana Love.
Aye.
Michael Mark,
Aye.
Stephen Pinelli, approved absence. James Ruane,
Aye.
Johnny Simpson.
Aye.
Motion passes.
Thank you, Mariah. I would now turn our attention to item 7, which is the review and discussion and possible action item on 2023 pending legislation. CSLB's legislative staff reviews more than 2,700 introduced bills and amended bills. They track those bills that affect the board and our stakeholders, as well as those which the board may wish to take a position on. Sometimes the legislature acts on those bills before the board has an opportunity to weigh in, which the board procedure manual has a process for addressing. With that, we'd like to discuss AB 336 by Assemblymember Cervantes, which begins on page 159 of your booklet. This bill would require licensees who are not exempt from workmen's compensation insurance requirements to certify on the CLB license renewal form the top 3 by payroll workmen's compensation classification codes endorsed on the licensee's workmen's comp policy. This bill would prohibit renewal without that certification, but provides a retroactive renewal if the licensee complies within 30 days after notification by the CSLB that the renewal has been rejected. Fauna, would you please describe or discuss this bill for us?
Thank you. I want to start this section by just stating that legislation changes quickly. So some things have changed since these materials were published. Consequently, status or locations have changed, and in some cases, our recommendations have changed. So I just want to point that out before I go into the legislation. So our first bill is AB 336 by Assemblymember Cervantes. This bill is sponsored by the District Council of Iron Workers of California. This bill was introduced last year as AB 2984 by Assemblymember Cooper, and it was held in the Senate Committee on Appropriations. So this is a reintroduction. This bill is intended to ensure that contractors are not committing workers' compensation insurance fraud by misclassifying their employees in a role that garners a lower insurance rate. For example, classifying tree trimmer employees as painters or classifying other construction employees as office staff. Last year, the sponsors worked with CSLB on amendments that were intended to lower the fiscal impact of this bill. So this bill includes those amendments. While we appreciate the sponsor accepting our amendments to only require the top 3 classifications, this bill does not address remaining concerns about the potential impact of the bill. For example, the intent of this bill is to prevent workers' compensation fraud, which is enforced by the Department of Insurance. We have no way of checking whether the top 3 classifications are accurate. When asked by the CSLB, when asked why the CSLB website would be the best venue for this information, the sponsor could not give an answer. However, this bill would create a fiscal impact of at least $227,000 for IT costs. Also, we still need to look into potential enforcement costs, as this bill does not specify who is responsible for enforcing requirements of this bill. If a contractor reports false information or if they are committing fraud, and that is posted to our website. This bill is scheduled to be heard by the Assembly Committee on Business and Professions on April 11th, 2023. Because the sponsors have proven willing to work with us, staff are recommending that the board watch this bill. This would allow us time to engage the sponsor in further discussions to reduce the fiscal and clarify CSLB's intended role here. If we cannot accomplish that by the June board meeting, staff would recommend and oppose then. But of course, we turn it over to the board. Back to Miguel.
Thank you, Fauna. I would ask for comments on this item from committee members, from board members.
Michael
Seeing
Mark
none.
has his hand raised.
I'm sorry?
Michael Mark has his hand raised.
Yes, please, Mr. Mark.
So did I hear correctly? You're asking the recommendation from staff is to watch this bill and report back at our June meeting? Is that the recommendation?
Correct. I would like some time to work with the sponsors. They're willing to, they already accepted our requested amendments last year. So I'm hoping to have a chance to work with them again to see if we can narrow this bill down to what they're trying to accomplish. I would like to limit the responsibility of CSLB on this issue because it falls within the jurisdiction of the Department of Insurance. I would also like to eliminate the fiscal if possible.
Okay, thank you.
Any other comments from the board?
Not the board. We have a hand raised by legal.
Feel free.
Good morning, Christy Schildt from the DCA Legal Office Counsel for the board. I think another legal issue which I've discussed with staff is the concern that you would be having responsibility for determining whether there's an appropriate workers' compensation policy. That's not really something that's typically within the expertise of the staff at this board. So my concern would be the liability you would be assuming for determining whether that workers' compensation insurance was adequate for the classification. So that is another area I would recommend that staff explore in discussions with the author's office, because this would be a new legal requirement for you that your staff would not be, at this point, my understanding, have the training perhaps and the expertise to do. So it may require you to hire more staff or personnel. So that should be something that should be considered in those discussions with the author's office. Thank you.
Thank you. If there are no other hands, I certainly do have a comment to make. When I look at this through several eyes, as a contractor, I personally, and I know many other large and medium-sized contractors, have more than 3 codes. I personally have 7 codes. So at what point do I fall out of favor or become non-compliant because I'm using 7 codes for my workman's comp policy, and there's only 3 slots here to make a determination? So my concern is, as legal said, how is staff going to make a decision as to whether I had the appropriate code, the appropriate 3 top codes, when in fact I have 7 or 8 codes? Secondly, my concern is, as we know, we're, DCA, just Department of Consumer Affairs. So I'm not sure, since we have legislation in place for 3 categories, and in January of 2026, all licensees will have to have workman's comp. I'm not sure how this protects the public any more than legislation that has already been passed that will provide the assurances that workman's comp is part of every contractor's policy. I'm not sure what adding the ability to know what the top 3 codes are, how that benefits the public and or protects the public. So Fauna, those are clearly some of my major concerns that I have with this piece of legislation.
Okay. Well, I can answer a couple of, or I can address both of your questions. So the top 3 were requested amendments from CSLB. They originally wanted us to list all, and to reduce the impact to our IT systems and workload, we requested that it be limited to the 3. However, you're right, that is not clear if we would be expected to enforce that or what our role would be. It's supposed to be by payroll and to address insurance fraud, which is clearly not our jurisdiction. So that is an outstanding issue. Your second question, this bill again, addresses insurance fraud. So it's not whether you have workers' compensation insurance, it's whether you're paying the correct amount. Again, this is not within the board's jurisdiction, but because the sponsor was willing to work with us last year, we would just like the time. But if the board prefers to take a position on this bill, we understand that as well. We see the same concerns.
Thank you, Fauna. So at this point, is there a motion to be made where, by the board to either oppose and or watch this AB 366?
This is Johnny. I think that yeah, I would make a motion to watch and continue to work with them to see if it's something that we would be interested in without putting ourselves. I mean, if they come up with something that doesn't give us any legal liability, sure, why wouldn't we support it? So why don't we just watch it? And from my experience, that's a huge deal in the construction industry, is on bid day contractors that are misclassifying workers to beat the bid on their workers' compensation. So I think it is a big deal, and I think that we should watch it and support it if possible without causing ourselves a bunch of liability.
This is John Cannon, legal again. Excuse me, Miguel. I'd consider that board comment on the issue of watching, since a motion's not required. I think the request was, do any board members wish to discuss a different position? Because watching is not one that needs to be voted on.
Thank you, John.
Michael Mark has a hand raised.
Mr. Mark, please, board member.
Yeah, I want to kind of echo off of Johnny's comments. I do believe it's if we're providing just public information, and that's my understanding of this bill, was that there was going to be some just public information of which codes for that particular license. I would say continue watching it. If board legal is saying that's not a motion, the only thing would be, so I was hearing that we needed a motion because it was changing the recommendation from neutral to watch. So I guess that's why there was some confusion there.
Any other comments? Thank you, Mr. Mark. Well, if there are no more board member comments.
Rodney's hand just went up.
Okay. Fire away.
Yeah, I'm also in favor of working with the authors to continue seeing what they could do to offer more information on it. And I echo pretty much John's comments.
Thank you, Ronnie. With that, Rico, are there any public comments on this item?
No public comments.
Very good. Mariah, would you please call roll?
Again, this is John. Miguel, apologize to interrupt, but if a board member has not presented a motion, then there is no roll to call. So I think the question you want to ask are there any board motions to be made? Because the recommendation is a watch, which does not require any motion. Does that make sense?
Okay, my apologies. So therefore, is there no vote for the position of watch?
Correct. So the question is, are there any board members that wish to make a motion?
I believe the motion I was trying to make is continue to work with the sponsors of the bill to see if CSLB can get what they need out of it, however that wording might be. Meaning we don't accept any liability for the enforcement of it, but see if we can, does that make sense? Am I making sense?
I believe.
Continue to work with.
Yes, I believe what you're saying. So the motion would be to continue the watch as long as the CSLB does not take on any additional responsibilities or liabilities on the enforcement of AB 336. Would that be stated properly, Johnny?
I think that sounds like a watch with questions, but a watch is not taking a position for or against. It's simply there's a recommendation before the board to watch. If a board member wants to make a recommendation to oppose with any conditions or support with any conditions, that would be a motion that would need to be made and seconded and then voted on. But if your concern is simply watch, maybe Fauna could explain that a little bit.
John, this is Johnny, and this is Johnny, and what I am asking is that Fiona continue to work with the sponsors of the motion, the same as we did last year, to see if we can get into a support position. So however that is worded.
Hi, I want to jump in. If you want us to just watch the bill and work with legislative staff and the sponsors of this bill, we don't need a motion. If you want to change that, which is the staff recommendation, then we need a motion. So if you want us to watch it and work with it, then we can move on to the next bill.
Good enough. Understood.
Thank you for your point.
We have a hand raised from DC Legal.
Rodney, did you have a point of order? Rodney? Go ahead.
Yes, I want to make a motion that we support it with the conditions that the CSLB assumes no liability as far as us in support of it.
So I have a question. So I'm trying to figure out where you would like the bill to end up. If you want the bill to not be supported, if it causes financial liability or any other liability for the board in administering these provisions, then it should be either an oppose unless amended or watch with the authority to delegate to the legislative chair the ability to change the position to oppose. So, I mean, those would be my recommendations. So I was trying to figure out whether Mr. Simpson was trying to make a motion to watch, and then if there is liability attached, then authorize the chair to change the position. But now Mr. Cobos, is it Cobos? I'm sorry, I mispronounced your name.
That's correct, Cobos.
Okay, Cobos. So if you could clarify whether you're in support of this bill as written with changes, or if you think it should be opposed unless amended to address any concerns for the liability of the board in administering or determining the appropriate classification and coverage for that classification.
No, my position is just to support it. However, to support with working with authors to get more information on it.